I now recognize myself for an opening statement. We are here today to resolve an important issue the committee and the United States House of Representatives has. Did Lois Lerner waive her Fifth Amendment privilege against self-incrimination during the committee hearing that began May 22, 2013? During the hearing that began on May 22, more than 5 weeks ago, I tried to be exceedingly cautious. I did not make a quick or uninformed decision on the waiver. Because the decision is one that does not often get made, and it is extremely important both to the discovery of Congress in its duties and, quite candidly, toward the real question of whether or not people will come and give one side of a story and not allow themselves to be cross-examined. As Chairman, it's my obligation to be fair and impartial and to lead this committee not on one side or the other, but to the greatest extent possible to make my decisions in concert with the parliamentarian, with House counsel, and consistent with what we would want to have if and when the gavel moves to the other side of the aisle. My job as Chairman is to bring the question to a vote so the committee could make a determination. As most know, when Congressman Gowdy made his assertion during the hearing, I could have ruled just that she had waived. I felt it inappropriate to do it, recessed the committee hearing, and informed Ms. Lerner that she was subject to recall after a decision was made. We have consulted and gotten advice with House counsel. Their capacity as attorneys for the committee and for the Congress is impartial. They have delivered to us both their opinion and the case law. Having now considered the facts and arguments, I believe Lois Lerner waived her Fifth Amendment privileges. She did so when she chose to make a voluntary opening statement. Ms. Lerner's opening statement referenced the Treasury IG report and the Department of Justice investigation, and the assertions she previously had provided, and the assertions that she had previously provided false information to the committee. She made 4 specific denials. Those denials are at the core of the committee's investigation in this matter. She stated that she had not done anything wrong, not broken any laws, not violated any IRS rules or regulations, and not provided false information to this or any other congressional committee regarding areas about which committee members would have liked to ask her questions. Indeed, committee members are still interested in hearing from her. Her statement covers almost the entire range of questions we wanted to ask when the hearing began on May 22nd. Today marks the 37th day since Ms. Lerner appeared. Since that time, I have considered the matter deliberately. I received letters from Lerner's lawyers that presented her arguments clearly and completely. Her letter will now be entered in the record without objection, so ordered. We considered it and sought appropriate counsel to reach our decision. Counsel had her attorney's letters and made their determination and recommendation. And now it's time to put it to a vote. With that, I recognize the ranking member for his opening statement.